The federal government has tabled legislation that would modernize how Canada's spy agency collects and shares intelligence. The legislation comes days after a public inquiry said attempts by other countries to meddle in Canada's past two elections undermined Canadians' trust in democracy.
Digital technologies are a part of every aspect of our lives, and this new context calls for CSIS to be more agile in how it can conduct its investigations. This is precisely what this legislation would achieve.
For more on this, I'm joined by Ward Elcock, who is a former director of CSIS. Ward, long time no see. It was just Friday you were here. You heard there from Dominic Leblanc talking about this will allow CSIS to be more agile in the way it conducts its investigations. How does this boost the agility of the spy agency?
Well, I assume what it does, it's a fairly long piece of legislation, and a lot of it is fairly complex. So understanding exactly what every provision does is not something you can do in 20 minutes or half an hour. But I assume what they're doing is they're tidying up a bunch of things that deal with investigation, but also clearly they're giving the service a greater ability to talk to people about issues that may come up in investigations. Now that's going to create its own problems, but that was something the government signaled that it intended to do.
Okay, so let's talk about that. Let's talk about the importance of that, because throughout this, like there's the internal information sharing gaps of whether the PMO was told or the public safety minister was told. This is about a broader series of information sharing at municipal governments, universities and private companies. What is the benefit of giving CSIS that specific range of powers, and any downside you might see?
Well, the benefits are that it can talk to people, because up until this point, the service was limited really to providing information to the government and then the government deciding what it would do with it.
Right.
So giving the service the ability to do that means that it can be more direct. It will be more challenging for the service because it will have to take some decisions about what information does it share and doesn't share. And there is a potential to create problems in an investigation by sharing too much. I think some of people's concerns that people be informed are probably unrealistic. It really, for example, it escapes me that Mr. Chong needed to know that the Chinese were interested in finding out something about his relatives. It's not clear to me, apart from the fact that he is a member of Parliament, why that would even be an issue.
Well, why wouldn't he want to know that? I mean, if it feels...
There's nothing he can do about it, and there's nothing the service can really do about it, except if somebody actually carries out that activity in Canada. But the reality is the Chinese are going to find that information out in China. They control Hong Kong. They're not going to have any barrier to finding that information. They may have tried to do it here for simplicity, but ultimately they'll get that information at home, and there's nothing anybody can do about it.
So the argument today in allowing CSIS to speak more broadly with people was that it could help build resilience. For example, we've heard about alleged meddling by the Chinese state in the Vancouver municipal elections, for example. And we've heard from the former mayor, Kennedy Stewart, that they were briefed by CSIS on what was happening, but it was maddening because of the lack of specificity.
And they may still have that problem,
right? Because
again, you're talking about top secret information. It may be information derived from a warrant. It may be information derived from a sensitive operation, from a human source or whatever. So the information they share may still not be enough, the kind of information that people imagine they should be getting. Now, whether they should be getting it or not is a question that the service is going to have to consider before it shares anything, and that's going to be tough to manage, I think.
There would at least be the opportunity, as I understand it, the way these changes were explained today, is that you could go to an organization, a municipality, a company or whatever, and say, you're being targeted by a foreign state. These are the ways they tend to do this. These are the steps you should take to protect yourselves. And right now, they haven't been able to do that necessarily.
So there are ways in which they can do some of that, and ways in which we have done some of that in the past. But the reality is that was hard to do. This will make it easier, and that will happen more easily. And that's not a bad thing necessarily, but it will involve some tough choices from time to time.
It's still unclear to me how a legislative framework that we've only just seen could help overcome the challenges of turning intelligence into evidence to take certain behaviors and bring them into the criminal realm. But there are changes here to the Security of Information Act, to the Criminal Code, which does criminalize certain foreign interference activities, from basic spreading of disinformation to try and meddle in party nominations. Things that were sort of in a gray area before are being very clearly, sharply defined as criminal behavior. What's the significance of that?
That's useful in the sense if it's defined as criminal behavior, because it allows you to take action against somebody who doesn't disclose that they're doing those things, and subsequently you find out they are, and that would allow you to prosecute them. In the past, if it wasn't a crime, then even if you found out, there's nothing you can do about it because they're not committing a criminal act. So that's useful. The intelligence evidence issue is a very, very broad issue and won't get fixed by this legislation because it's really fundamental, at its fundamentals, a constitutional issue.
Yeah.
And you can't, unless you wanted to notwithstand the Constitution, you really can't fix that one overnight.
Yeah, that's really...
I mean, there have been a number of fixes over the years, and the way in which the RCMP and CSIS in particular cooperate now has fixed some of those issues. But the reality is that's a constitutional issue unless the courts step back from their interpretation to date. Then that's not fully fixable.
Right. So it seems like in terms of trying to influence certain things on behalf of a foreign agency, a foreign actor, or a foreign state, there is the new registry they're proposing with the new Foreign Influence and Transparency Commissioner, which forces you to register there and be subject to fines and penalties if you do not register and engage in certain activity. But then there's also just criminalizing meddling in the electoral process, whether it's everything from a school board election to a nomination. So that seems to clean up some of those challenges at the school board and lower levels of state activity, does it not?
Yeah,
at least in terms of legal framework.
It makes it much clearer. It allows you to enforce the law if you identify somebody who is actually doing that without having registered. If they've registered, then they've declared it, but it helps you when they're doing it in some sense in a more clandestine fashion.
Is that how you
won't deal with the people who are totally clandestine and who are never going to tell you anyway?
Right, but on that, it seems to me there's influence activity that needs to be registered with the registry, and then there's trying to interfere in electoral processes, and they seem to be two separate things, right? One is purely criminal, and the other is the registry compliance. So because for example, using the example of Don Valley North, which you've been talking about, the buses of students that were alleged to have come in allegedly with China's involvement, that's now very clearly criminal if this legislation passes. But on the registry, just help me understand that word, because this is something the United States has had for 8-9 decades. Australia's had for about 5-6 years now. What does that exactly curb? Is it just a transparency measure, or is it sort of a way that if you haven't registered and you're engaging in pressure on diaspora communities, we can get you this way? It's a bit like a Al Capone and tax evasion thing.
It does do that, and I think the example that a lot of people give is the example in the United States under their registration legislation. They were able to arrest 2 Chinese officials who were busy putting pressure on Chinese citizens in the United States. That clearly is something that the registry would deal with. It will also, I think, clarify who in society is representing a foreign government in their day-to-day dealings, which up until now we may not have known. It may be interesting to know, for example, who is working for the government of India or who is working for the government of China. Up until now, we really haven't known who's receiving a stipend to do things for the Chinese or the Indians or others. And I think that's not a bad thing to know in society. And ultimately, if you don't register, that allows you to be prosecuted as well. It won't do much about the rest of foreign interference. It's not going to fix the problem for communities, diaspora communities in Canada. It's just simply not going to do that, because the reality is their problems are different, and most of the pressure that's put on them is put on them by clandestine agents who aren't going to come and tell us that they're doing what they're doing or register or whatever. I mean, they may in fact be agents of a foreign power, and in some cases they may be Canadian citizens who believe that the foreign government, that we need to be closer to that particular foreign government, and we need to be agreeing with that foreign government, and therefore they want to encourage people in Canada to support that foreign government's position rather than the government of Canada's position. How do you prosecute prosecute those people.
Right. So how do you get at that problem, just as a final point? How do you get at people who are pressuring diaspora members? Because this has been the consistent theme throughout everything, is that they have been getting pressured, they say, for decades, especially in the Chinese-Canadian community, and it's not being dealt with. Is there a measure here?
No, I don't see one, although some of the criminal effect may give you a leg up in some cases, depending on how it goes. But I think the reality is that ultimately depends on intelligence work and identifying who are the practitioners. Some are harder to eliminate than others. For example, it's very hard to deal with the Iranians who do a lot of it over the telephone. How do you deal with that? How do you deal with stuff that comes over WeChat? Tell people to not listen to WeChat, but that's about the only solution you've got.
Okay, Ward Elcock, former director of CSIS, always appreciate the time. Thanks for coming in today, sir.
My pleasure.
Appreciate it.